topic chosen for this two-day national conference is very apt. We have completed 75 years of adoption of Constitution of India. So we have traveled a long journey, but is it enough? We have yet to travel. A journey is never complete unless until we achieve the goals. So what are the goals of our Constitution? Have been very detailed, in a very detailed manner, have been outlined by my sister Nanda. She has brought out how the Supreme Court, being the guardian and interpreter of the Constitution of India, has made key changes in the society, have interpreted the law, and have paved the way for various reformative laws in the country. This two-day conference may not be sufficient to really discuss all those issues. And I have seen the theme, sub-themes, and they are varied but very, very needed subjects. I'm sure you'll be publishing a book of the best papers on those topics, and I'm sure that they'll be helping the lawmakers also in framing new laws. Professor Balkista Reddy in his speech has brought out the new challenges that we are going to face. Till now we have been dealing with only domestic problems. But the Supreme Court and as well as the High Courts also have been dealing with some issues relating to international, which fall in the international arena. One is the human rights. The most important one is human rights. Till now, whatever decisions have been rendered, maybe with regard to, are mostly with regard to the human rights. And what you say is also right that, because of the world becoming a global village, we are going to face many challenges. And as an income tax judge, I was also dealing with international taxation. So once tax also comes in, then definitely it's going to become a domestic issue very soon. And we, as judges, also have to be prepared for dealing with such issues. Students are the future of the country, so you need to update yourself and be prepared for the challenges that are going to come ahead. So one of the key, most important, as long as human beings are alive, this world is there, the issue will be of human rights. And therefore, I have chosen the topic of gender equality under the Constitution of India. I'm happy to be part of this inaugural session of the two-day national conference on the working of the 75 years of the Indian Supreme Court, an academic revisit. Since the theme of this seminar is to deliberate on the impact of Constitution and its organs on the socio-political landscape of India, I thought it appropriate to speak on gender equality under the Constitution of India. Women are 50% of the population the world over, and India is no different. And therefore, they are equal partners, and their status in the society would have impact on the economic and political development of a country. Before we embark on this journey, it is necessary to understand the status of Indian women over the centuries. Studies show that in ancient India, that is Vedic times, men and women were treated alike in all spheres of life. According to Rig Veda relics, women married at a mature age and were more likely allowed to choose their own husbands, which show that during the early Vedic period, women had equal position and rights, having access to education, and also contributed to the economy. However, women's status began to deteriorate around 500 BC with the invasion of India by foreigners. Perhaps initially to protect women folk from the atrocities by the invaders, they were subjected to confinement and restrictions, but later it became a norm, which in turn led to deprivation of higher learning, and limiting their roles to domestic duties. Over a period of time, their position was worsened, and child marriages, that is, marriages of girls of 5 to 8 years, were performed with older women to ensure their security and the continuity of lineage through sons, and slowly it became a social and cultural norm. The society was also plagued by inhuman practices such as sati. During the British rule, reformists such as Raja Ram Mohan Roy fought against the practice of sati and child marriages, leading to abolition of sati. Social activist Ishwar Chandra Vidyasagar advocated widow remarriages, which led to passing of Widow Remarriage Act of 1856. Educationist and social reformist Jyotirao Phule battled for the education of girls and started schools for them as back as in 1848 in Pune. The first women's delegation was organized by the Indian National Congress in 1917 to seek women's political rights. The All India Women's Education Conference was held in Pune in 1927, which brought about social change movement and Child Marriage Restraint Act in 1929, requiring a girl to be of at least 12 years of age before marriage. Imagine, 12 years of age. The positive effect of freedom struggle is that it provided a platform for women to step outside domestic confines and to participate in public life. Post-independence in 1947 and with the adoption of the Constitution of India in 1950, emancipation of women under a legal framework began. The Indian legal framework, which is historically patriarchal in structure, has progressively evolved to incorporate gender-just jurisprudence. The Constitution guaranteed fundamental rights to all its citizens and equality before law and equal protection of laws under Article 14, ensuring that women have equal rights and opportunities. Article 15(1) prohibits discrimination on grounds of sex, and Article 15(3) allows for special provisions to be made for women and children. When we discuss freedom of equality, many ask, when everybody is equal, why do you need law, separate law for women? Why reservations for women? So therefore, the Constitution, having regard to the socio-political status of women at that point of time, has thought it fit to include Article 15(3), allowing for special provisions for women. Article 16 ensures equal opportunities for all citizens in matters of public employment, granting access to women in government jobs on equal footing with men. Article 13(9)(d) mandates equal pay for equal work for both men and women, promoting gender equality in employment, and Article 42 directs the state to ensure reasonable and humane working conditions along with maternity welfare for women workers. In addition to these provisions and reforms, the socio-political conditions exhibited the need for special laws to protect women and prevent their discrimination. To increase and ensure participation of women in decision-making process, Articles 243(d)(3) and 243(t)(3) were introduced to provide for reservation of 1/3 of total number of seats for women in local government bodies. The Child Marriage Restraint Act of 1976 was passed, raising the marriageable age of women to 18. You can see how long it has taken to increase the marriageable age from 12 to 18. Emphasis was laid on girl education and employment. However, women faced further evils, such as dowry harassment and domestic violence. Thus, the Dowry Prohibition Act of 1961 was passed. The Protection of Women from Domestic Violence Act of 2005 was enacted. And when women started facing sexual harassment at workplaces, the Honorable Supreme Court, in its judgment, popularly known as Vishakha judgment, had required the government to provide proper framework for protection of working women, and thus the sexual harassment of women at workplace Prevention, Prohibition and Redressal Act of 2013 came to be passed to ensure a safe and dignified work environment for them. In order to ensure job security to women employees during pregnancy and after childbirth, and to protect their health and well-being in workplace, the Maternity Benefit Act of 1961 was passed. The period of maternity leave has also been enhanced suitably. All of these constitutional provisions and laws have been enacted to promote gender equality, empower women, and protect their rights and interests in India. So when we speak of gender equality, is it only the equality of women along with men? It is a human rights issue. It is therefore necessary to look at it as a right belonging to everybody. In order to ensure economic empowerment of women, the Hindu Succession Amendment Act of 2005 was passed, granting co-parcelary rights to daughters, ensuring equal inheritance in ancestral property under Hindu law, affirming the principle of testamentary equality. But as far as Muslim women are concerned, they are governed by their personal law, and they inherit only half of what their male counterpart inherits. Correct me if I am wrong. The Muslim Women Protection of Rights in Marriage Act of 2019 makes instant triple talaq a criminal offense, ensuring fair procedure and safeguarding the marital rights of Muslim women under personal laws. As regards their entitlement for maintenance after divorce, they could claim only under their personal law. But after the judgment of the Honorable Supreme Court in the case of Shah Bano, holding that a divorced Muslim woman has a right to claim maintenance under Section 125 of CRPC. Section 125 of CRPC was held to be secular. It's not particular to any particular community. The Maintenance under Muslim Women Protection of Rights on Divorce Act of 1986 was passed. In a recent judgment, the Honorable Apex Court, in the case of Muhammad Abdul Samad versus State of Telangana and another, held that a Muslim woman divorced under Muslim law is also entitled to claim maintenance under Section 125 of CRPC, that is Section 144 of VNSS. With decrease in the ratio of men to women and to prevent the sex-selective abortions, the Preconception Prenatal Diagnostics Techniques Act of 1994 was introduced by regulating medical tests and making it illegal to determine the sex of an unborn child. More than a page has been spent on reading out the different laws that have been passed to preserve the rights of women and to prevent their discrimination. But is it enough? The data shows that even though substantial legal reforms have been introduced over the past few decades, implementation, awareness, and enforcement remain key challenges as on date. Though women's rights are protected and enforced through a variety of statutory enactments, constitutional provisions and judicial pronouncements together forming the corpus of gender-sensitive legal discourse in India, in this 21st century, India stands at a crucial intersection to transform these legal rights into realities. Though all the above steps have shown some certain positive results, you can see on the stage, 3 of us are women judges sitting here. The female literacy rate, as per Census 2011, is still only 65% as compared to 82% of males. Female labor force participation in 2023 was only around 25%. Though Women's Reservation Bill, through Women's Reservation Bill of 2023, granted 33% reservation in Parliament and state assemblies, actual representation remains below 15%. The maternal mortality rate dropped from 130 in 2014 to 97 lakh per live births in 2020. Therefore, we can see that substantial efforts have been made with time towards women's empowerment, yet a lot more needs to be done to end the bitter legacy of inequity and to get a better deal by the better half of the community, humanity. Therefore, I am sure that you have a lot of topics to discuss. In these 2 days conferences, you will be deliberating upon these challenges and discuss and try to arrive at appropriate solutions to suggest to the lawmakers to make laws, not only to protect women and to all the human beings. I thank the organizers for giving me this opportunity to share my thoughts with you all. Thank you.